Thank you, Jeff. You're a very brave and hardy band of souls who come here in preference to listening to a talk by someone intimately concerned with the O.J. Simpson trial, and we're grateful to you for your discernment. It's my distinct pleasure to introduce to you Professor Harry Gelber of the London School of Economics. I knew Professor Gelber briefly 30 years ago at the Harvard Center for International Affairs, where he has had several stints. He claims to have been trained at Cambridge. I asked him then where he had been educated, and he received also some of his education in Australia, where he taught for 25 years before becoming a university professor at Boston University in 1993, and he served in that capacity until 1998 when he returned to England to the LSE, where he is now. He is a man of parts, and it would take me some considerable period of time to tell you about all of his publications, most of which are in the field of international relations. He has in press at the moment a book on colonialism, which I've had the pleasure of reading recently, and which will be out from Macmillan's in some months. And he's been working now on the exceedingly important and current topic, although largely neglected topic in Britain, of constitutional change. As you know, a great many constitutional changes are underway in Britain at the moment, many of them flying beneath the radar of the British public, much less the public of the rest of the world. And I look forward, as I'm sure you do, to hearing Professor Gelber tell us about them. Thank you.
Thank you very much, Don. Ladies and gentlemen, thank you for coming. I really do appreciate the idea that you might prefer listening to me to hearing about O.J. Simpson. That is a very, very great honor you're doing to me. Those of you who follow British affairs at all would have been struck in recent times by the cascade of books and articles dealing with or lamenting the death of Britain. Britain is supposed to be at the end of... Britain is supposed to be about to disintegrate as a result of a variety of things: Celtic separatism, sovereignty problems with the European Union, immigration, family collapse. And what's happening in Britain has been compared by some lamenting observers with the Roman Empire and its decline. And I would just want to give you a flavor of the sort of things being said. The same decay in agriculture, the same growth of luxury and desire for bodily comfort, the same distaste for the burdens of married life, the same decline in the birth rate, the same excessive taxation, the same decadence in public morals, the same substitution of state guarantees, of state gratuities for parents' duties, the same love of display in social life, the same lust for gladiatorial exhibitions of athletic skill, the same decreasing sense of national responsibility and self-sacrificing patriotism. Now that was an Oxford scholar writing in 1913. So not everything is new. A good deal of the turmoil has been going on for some time. But what I wanted to suggest to you is that because a good deal is not new, that doesn't mean that new things aren't happening, because they are. And I want to suggest, without attempting to predict what will happen in future, that several kinds of changes are happening which taken together are more far-reaching than the sum of the parts. It may not look dramatic, but then, as you know, Britain has a pleasant habit of dealing with revolutions by looking the other way and pretending they're not happening. I want to address all this under 5 general headings. Firstly, the composition and powers of Parliament. Secondly, devolution, especially to Scotland and Wales. I'm not going to talk about Northern Ireland, not because Ireland is not important, but because it's a very complicated issue about which I really don't know quite enough to comment in the context that I'm speaking of today. Changes in the civil service, thirdly, then changes in the law, which strike me as particularly significant, and finally the issue of the European Union. And what I want to do, and I hope you won't think that that's too unsatisfactory, is rather than talk in detail about any one of these five, about all of which you will have heard at least something, I want to try and suggest that the totality, in fact, is particularly interesting and too little commented upon. First then, Parliament. Here there are, in my view, three major issues. The composition and powers of the upper house, the House of Lords, or if you prefer the American term, Senate. The change from first past the post elections to the House of Commons to proportional representation, or the suggestion that that should be changed. And tensions flowing from broadly changed relations between Parliament and the people. Now, as you know, the Parliament Act of 1911 changed, or rather ended, the Lords' power over finance, and was also at the time meant, clearly, explicitly, to be the first stage in moving from a membership of hereditary peers to membership by election. Of course, it didn't happen, partly because all governments rather like to have a House of Lords without democratic legitimacy, and therefore unable to challenge the Commons, which itself was more and more under the influence, if not control, of the executive. Mr. Blair came into office, the present Prime Minister came into office, promising to expel the hereditary peers, but quite obviously with no very clear idea of what to do after that. In the event, he agreed with Lord Cranborne, the former Tory leader of the House of Lords, leader of the Tory faction in the House of Lords, to retain some 92 of the hereditaries elected by their fellows, in addition to the 567 or so life peers and bishops, and he did that largely to get his legislation, including this particular piece of legislation, passed smoothly by the then existing House. Now, it was evident from the beginning that Mr. Blair did not want a new House with greater powers than the existing one, if indeed as much as that. Much of the political public, by contrast, would like a strong elective element, which, being legitimate, would have greater powers of resistance in checking the executive. A bipartisan commission under a former Tory Conservative cabinet minister, Lord Wakeham, as you may know, suggested a mixture of appointed and elected members, and there is indeed to be an independent commission to handle the appointments process, though the membership of that commission is itself not yet clear, or wasn't when I left London about 10 days ago. Only three things on this are now quite clear. One, that the government is in no hurry at all to go ahead with further reforms. In fact, the latest suggestions are that quite certainly nothing will happen for another 3 or 4 years. Secondly, that the Prime Minister, who has already created more life peers than any previous Prime Minister, indeed by the beginning of this year he had appointed some 200 of them, he will balance the House, in his own terms, by creating enough new Labour peers to balance the previous Tory majority in the upper house. And three, he will continue to decide how many peers in future each party gets. In other words, he will control the balance of parties in the upper house. Now, there are, of course, difficulties about all of this from his point of view. First of all, Lords, once appointed, may not do as they're told. One example of this sort of pattern is what happens, as you well know, in this country with appointments to the Supreme Court. Presidents and the Senate may have particular views as to the kind of people they wish to appoint because they expect them to behave in certain ways once they're on the court. But once these persons are on the court, they may in fact behave quite differently. Now, similarly, once life peers are appointed, they may not do as people thought they would. Secondly, even the present House, partly reformed as it is, has been much more assertive than the government, I think, expected. And the government has been defeated on several issues of considerable importance. For instance, on jury trial, the government was proposing to abolish the option of jury trials for certain classes of offences, and the Lords have just thrown that out. Or again, Clause 28 of the Local Government Act, which has caused an enormous stir in England. In brief, Clause 28 of the Local Government Act contains language which suggests that schools controlled by local governments may talk about but must not promote homosexuality. And the repeal of that section, it has been argued, would allow homosexuality to be actively promoted in schools, and the Cardinal of Scotland, a raft of Anglican bishops, and the Chief Rabbi of Britain have all said, no, this must not be repealed. So there's been a big fuss. And anyway, the Lords have certainly stopped the repeal of Clause 28. Or again, there are various other issues that we can go into. Now, the government does, of course, have the ability to use the Parliament Act, that 1911 Parliament Act, to override the laws. But there are difficulties about that too. Partly difficulties in the present context in terms of time. It will take the government so much time, for instance, to reintroduce and push through the act that would abolish jury trials for certain offences, that it would find itself, if you try to go that route, it would find itself going into the next election by May next year with that issue hanging around its neck. And it certainly is not going to want to fight the election in any sense with that in play. Also, in addition to all of this, the Lords will have a variety of opportunities, do have and will have a variety of opportunities for delaying acts or proposed acts of Parliament, referring stuff back to the Commons and asking the Commons, the lower house, to think again. Altogether, there will, for instance, be an end to the custom of the old house of not opposing secondary legislation and regulation brought in by the government in pursuant of, rather generally, acts of Parliament framed in general terms that have been passed previously. Now, regulations of that kind can be opposed and at least delayed, if not referred back to the Commons. Next, there is this business of proportional representation. The smaller parties, in particular the third largest party, the Liberal Democrats, have of course long claimed that first past the post is very unfair to them, because the number of seats that they get in the lower house of Parliament is dramatically less than the percentage of their voting in the general election would suggest. And Blair has wanted to create, and I suppose still wants to create, a broad centre-left coalition as the natural party of government in Britain. And he has promised, and not quite withdrawn the promise yet, to the Liberal Democrats to hold a referendum on the subject. But it's not quite clear when such a referendum might be held, so the matter is in abeyance, partly because his own people are really very pleased with the present system. Moreover, if the Labour majority, the present huge and unprecedentedly large Labour majority in the House of Commons of something like 179 seats, declines, he might need the Liberal Democrats to retain government. But as I say, the idea has faded, partly because his colleagues have impressed on him the fact that after all, Labour's huge present majority was one under the existing first-past-the-post system, so the system can't be all bad. Secondly, obviously, proportional representation would create splinter parties, and it would certainly change the topography, if you like, of politics in Britain, as it has already produced coalition governments and difficult balances in Scotland and Wales. On the other hand, the issue will of course not go away, because proportional representation is already established, for instance, for European elections. So there's a good deal to play for still here. Then there's the more subtle and inchoate matter of representation and executive government, in a period when executive government has moved further away from Parliament than used to be the case half a century or even less ago. Now, let me not overstate the case, because of course the established constituency basis for representation remains really quite decisive. It remains decisive because of the help that members of Parliament can give to individual constituents who've got problems, and not least because the members of Parliament of a given political party do, after all, form the electorate that selects the party leader and prime minister, which is no small matter. On the other hand, of course, party discipline has tightened very greatly over the last half century, or even less, and that has led to increasing executive dominance. All of which is illustrated by the fact that Blair himself pays very much less attention to the Commons than most of his predecessors did. That may be true of Margaret Thatcher, but certainly much less than his predecessors before Thatcher did. And his great popularity, and it is great, it continues to be almost unprecedented great, does not rest on his parliamentary performance. And in fact, it's quite noticeable that when he and the Conservative leader, William Hague, clash on the floor of the House, Hague tends to win almost all the time, but none of that is reflected in a decline in the Prime Minister's personal popularity in public, which is not really dependent on his parliamentary performance. That again is a historically new situation. Blair has illustrated all of this in an interesting way, in an incident that wasn't much commented on. Back in, I think it was June last year, when the Kosovo thing was going on. At one point, Blair happened to be, I think it was in Albania, in an open lecture, talking among refugees, giving lots of lovely photo opportunities to TV and so on. And while he was away, 60 members of his own party voted in Parliament against a government proposal to cut certain benefit rates for handicapped people. We don't need to go into the details, but they voted against their own party. Now, the government won the vote anyway because its huge majority allowed it to do without 60 of its own members. But when Blair came back, he called the Parliamentary Labour Party together and read them the Riot Act. And what he said was that they mustn't think that they are the ambassadors of the people to the government. No, no. They're the ambassadors of the government to the people. And their job is to represent the government and the program on which it and they were elected to the people. Now, what's not only interesting is the fact that he said this, but that almost no fuss was made about the statement. And the reason why no fuss was made about the statement was that everybody could see that that was actually the real situation, desirable or otherwise. But yes, indeed, that is increasingly how it is seen to be. What is therefore happening is that increasingly issues, I don't mean issues affecting individuals, which can then be taken to individual members of Parliament who may or may not be able to help, but bigger issues, environmental ones or highway building and so on, are in the hands not so much of constituency representatives, but in the hands of pressure groups of national scope. And again, I can illustrate that quite simply with a set of figures. All political parties in Britain put together are reckoned to have membership of something like 800,000 people. The Royal Society for the Protection of Birds has 1 million. Okay? So what is emerging, has emerged indeed, is very interestingly, is a quasi-plebiscitary system supported to an increasing degree over the last 25 years by referenda, which is naturally in some degree of tension with the traditional representational role of the House of Commons. So let me move on to devolution, the second theme I wanted just to comment on. That issue had gathered a good deal of steam by the time Blair came to power. He had inherited it from John Smith, his predecessor, and the whole issue had gathered steam, particularly in Scotland, and he couldn't have dropped it if he'd tried. though it's quite clear that Mr. Blair is not particularly keen on devolution. Anyway, the result has been, as you probably know, that there are a Scottish Parliament and administration in Edinburgh, there's a Welsh Assembly and administration in Cardiff, and there is about to be a Mayor of London with an Assembly. The Mayor is due to be elected, I think I'm right in saying, in May. Now, clearly there have been strenuous attempts to keep real power in Whitehall and in London. The formal powers of the Scottish, Welsh and London administrations are very strictly limited. All are statutory and not sovereign bodies. Scotland has very, very minor taxing powers, but apart from which all three, the Scots, the Welsh and London, get their money by grant from the Treasury. So there's no question as to who holds the purse strings. Labour is in power in Scotland and in Wales, and may well be in London, though it is not entirely clear what will happen there. Neither Scotland nor Wales has an independent civil service. What they have are separate branches of a single British service, whose head is the head of the civil service in London. But that, of course, is not the end of the matter. Mr. Blair's attempts to put his own nominees into power have failed in Wales, are to a degree trembling in Scotland, and may well fail in London, where a man whom Mr. Blair dislikes entirely, Mr. Livingstone, who's a well-known lefty known as Red Ken, is hugely, hugely popular, and if he decides to stand as an independent, might yet win the mayoralty. The Labour Party fixed the question of who should be the Labour candidate by various means that many people consider devious, and the formal Labour nominee is a fellow called Frank Dobson, who was until recently Secretary of State for Health, and who is widely considered to be Mr. Blair's poodle, which does not at all make him popular with the general electorate in London. Okay. Moreover, the Labour ascendancy, or in Scotland, the Liberal Democrat alliance, might not last. The Scottish and Welsh nationalist parties, which want much greater freedom of movement, still exist, although they've piped down recently on this. And relations with London, between Cardiff and London and Edinburgh, may look very different once different parties are in government in these different places instead of members of the same party. There is more, including what is widely known as the West Lothian question. In effect, is it fair that Scottish MPs at Westminster should be able to vote on English issues, while English members of Parliament have no voice on Scottish issues dealt with in Edinburgh? Moreover, what happens in England when, at some point, at Westminster, the Scottish and Welsh MPs carry some narrow vote against the English members? Would England be happy about that? And yet Mr. Blair's party at Westminster needs its Scottish MPs, not only as part of the obvious strategy for holding the United Kingdom together, but because Labour currently holds every single seat in Scotland, where the Tories have been hugely unpopular. And Labour may depend on the Scottish seats again, once the balance of forces at Westminster is more even than it now is. There are other issues. For example, London spends more per capita on Scotland than in much of England, which the English are beginning to notice. The mayoral election in London has aroused particular interest, and there especially personality seems quite certain to play a much greater role than party labels and party loyalties, and it seems equally certain that the electorate in London actively wants the mayor to stand up to central government as much as possible. Now, to be sure, the mayor will have very limited powers. Central government can limit London's expenditure and issue guidance even about its general powers, but the mayor will have the legitimacy of being based on the largest personal mandate of any politician in Britain, the mayor will be directly elected by an electorate of some 5 or 6 million people. No other politician in Britain is anything remotely like that. And it's difficult to believe that any Prime Minister, Mr. Blair or any of his successors, will be able to disregard that. So the new patterns are still settling down, and there are ripples and there are difficulties, and there is certainly a muscular desire for self-government and greater degree of autonomy in various places. But I have to report to you that so far, and I stress that because I'm not in the business of prediction, so far the desire for independence, full independence, is by no means gaining ground. If anything, it's receding in both Scotland and Wales. Let me move on in connection with that to the changes in the civil service, which are moving in directions that you in America will find quite unremarkable, but which in British terms are really quite novel. The most important are three. Firstly, there are new rules for recruitment and promotion, including sideways recruitment from outside into the civil service, including the senior branches of the civil service, recruitment from business and elsewhere. An insistence on much better management performance, managerial performance, with bonus payments, would you believe, bonus payments for performance offered to senior civil servants. Now, as I'm sure you know, the British civil service has always prided itself on its Mandarin-like insulation from politics. It has maintained that it is, and indeed it has very largely been, a non-political, technical assist to successive governments, able to serve governments of all colours with equal enthusiasm and dedication. So in this new context, there has been a good deal of agonized debate as to whether the impartiality, the traditional impartiality of the civil service, will in fact be affected by this process of sideways recruitment, bonus payments, and what is seen as increasing politicization. Does it damage the civil service? Secondly, and more subtly, there is a shift of ethos of the service from policy planning and legislation, which is its traditional role, of course, to the efficient delivery of services, actual services on the ground. Social services, health, all sorts of other things. And here again, there are bonuses for performance. And the shift of emphasis, as I say, is difficult to pin down precisely, but the ethos is being promoted from on high, that's to say, by the Prime Minister and by his immediate staff, and of course by the head of the civil service. All of this is reflected, among other things, in greatly strengthened cross-departmental machinery for the phrases joined up policy. In other words, stuff that transcends the borders of any one department, which means almost everything. Thirdly, of course, there is greatly strengthened politico-administrative machinery working directly to ministers. Again, this is not in principle new. You've had specialist advisors to politicians really ever since Gladstone. And of course in this country the notion that senators and politicians should have their own staffs is of course by no means new. And indeed, politicians here have staffs, senators for example, and congressmen have staffs whose size and competence and so on British MPs can only marvel at. But you do now have greatly strengthened political administrative machinery working to these people. There is not only the tightly run policy unit working directly to the Prime Minister, which has now expanded oversight over virtually the entire government, but you have greatly increased numbers and scope for special ministerial advisors recruited from outside. And just to indicate, the numbers and costs of these specialist staffs have roughly doubled since 1997 when Mr. Blair came to power. Mind you, I repeat, it's all still quite small beer by Washington standards, but in British terms, this is really a substantial change. And again, there is agonized debate about whether that means an undesirable overlapping of party and governmental functions. Next, there is the business of law. and I realize that I'm being foolhardy in commenting on law as a mere political scientist, being not just a Daniel in a den of lions, but in a den of lawyers, which is arguably worse. But I think what needs to be stressed, and I really do think that what's happening is arguably the most important group of changes to overtake the British legal system since, I'm not quite sure when, but as the British system has developed since Magna Carta, this is perhaps the biggest single change. Anyway, we can argue about that. And I don't want to talk so much about the dominance of European law, in meaning the European Court of Justice, although that's hugely important, but about the European Convention of Human Rights, which goes very far to transform Britain into a rights-based legal culture, which, as you know, is really quite new over there. Why? Why this dramatic change? Because by now Britain needs a primary legal instrument to control both parliamentary excesses and the overweening power of the executive, a power which has been extended over decades by incursions into the law of the land of secondary legislation and regulation, all of which has created a regulatory jungle hugely dominated by the executive. Now, the Convention has already been introduced into the Scottish legal system as part of the changes that produced the Scottish Parliament and the Scottish election. It's due to come into force in England probably, though there are some slight doubts about it, in October, although obviously everybody is already adjusting to the impending role that the European human rights law will play. And it will be introduced on the basis that the Convention will govern not only all past legislation, but all legislation to be passed by Parliament in future. Now again, it's important not to exaggerate, because the impact of all of this is subject to important limitations. Britain could, in theory, repeal or amend the Act of Parliament that incorporates the law, the Human Rights Convention, into British law. Or at least theoretically, Britain might just ignore an adverse ruling, which has of course no mechanism for enforcement, although in fact, of course, Britain has usually been quite punctilious about accepting the court's judgments and acting accordingly. In more practical terms, the court will not be able to strike down statutes in a way that I think I'm right in saying the Supreme Court can strike down statutes here. The court will only be able to grant a declaration of incompatibility, then leaving it to the government and to Parliament to decide how to remedy the discrepancy that is declared to have occurred. But it's already clear that a huge range of industrial and social customs and structures will have to be changed. All past legislation and regulations to be reviewed to see whether it accords with the Convention, and if not, what changes might be needed. Obviously a vast job. Citizens can now sue their own government, which again in British terms is quite new. Almost every aspect of business or employment will be affected. One obvious example, just to illustrate, is the business of homosexuals in the armed forces. The court declared not long ago that the human rights of people who had been forced to leave the armed forces because of homosexuality, that their human rights have been infringed, and the law has now been changed so that recruitment and membership of the armed forces to homosexuals and lesbians is open. Subject to certain obvious business about the way that you behave, whether you're homosexual or heterosexual, while you're, as it were, in a submarine or on a ship or whatever it is that you're doing. But matters go very much further. I will draw to your attention, if I may, Article 6, paragraph 1 of the Convention, which entitles a defendant to a fair hearing before an independent and impartial tribunal. The court itself has held that whether a judicial body is independent depends primarily, and I quote, on the manner of appointment of its members and their terms of office, the existence of guarantees against outside pressures, and whether it represents an appearance of independence, unquote. That's already led to the elimination in Scotland of the appointment of temporary sheriffs. Permanent sheriffs are okay because they can't be influenced, but the suggestion has been that temporary sheriffs might, while they're not being sheriffs, be subject to outside pressures, and therefore it is a violation of the human rights of defendants to be tried by temporary sheriffs. This has caused great confusion in Scotland, because of course the Scottish legal system has had to adapt quickly to the abolition, in effect, of the entire temporary sheriff system. Consider also, if you will, the case of Mr. Richard McGonnell. Please indicate if you've heard of Mr. Richard McGonnell. Nobody has. I commend him to your attention, ladies and gentlemen. Mr. Richard McGonnell is a citizen who lives on the island of Guernsey. Back in 1985, 6, something like that, Mr. McGonnell moved some flower arranging business into a shed, only to find 2 or 3 years later that some of his crops were ruined and things were blown down in a storm, so he wanted to vary the use of the shed. Okay? He was refused by the planning authorities, took them to court, and the senior judicial body on Guernsey also refused permission on the grounds that what he was proposing to do violated the Guernsey Development Plan. Mr. McGonnell thereupon took the United Kingdom to the then Commission on Human Rights in '98, and this has wandered its way through to the Court of Human Rights, which pronounced last month in Mr. McGonnell's favour, saying his human rights had been violated. Why? Because the Guernsey court that had pronounced against him had been presided over by a person called the Bailiff of Guernsey. And the Bailiff of Guernsey combines in his own person the senior judicial role on the island and the senior executive role on the island. Now, the panel of judges that rendered this judgment in the European Court of Human Rights had as a sort of additional, as a courtesy, they included a man called Sir John Laws, who was a British judge. The panel was chaired by a Frenchman, and the others were of other nationalities. But Sir John Laws wrote a concurring judgment because he could see where all this was leading. And the concurring judgment says, in effect, that while he, Laws, agrees with what the court has decided, the grounds for that decision are to be very narrowly construed and should not be taken as a precedent. Well, now, that's all very well for John Laws to say, but other people, including senior legal persons in London, have said, hey, now what happens to the Appellate Committee of the House of Lords, whose members are members of Parliament, i.e. the upper house, and the highest court in the land? If anybody challenges the House of Lords, is Britain going to have a new Supreme Court of its own? Well, that's fairly big stuff. Not only that, but an even prettier case is the case of the Lord Chancellor, who is himself a member of the Cabinet, a member of the upper house, and a senior judicial figure. Is it going to be possible to go on having a Lord Chancellor in England? And if not, what kind of rearrangement will this cause? So you can see that Mr. Richard McGonnell may have started something. In addition to all of that, there's the question of retraining the entire British judiciary, I'm not putting this too strongly, in the implications and the application of human rights law, which of course comes into Britain as an innovation. Furthermore, given that the Human Rights Convention has something of the character of a constitutional document, in other words, there are large gaps which are left, as in the US Constitution, to be filled in by a body of successive judicial decisions. And even if one does not go as far as Judge Bork in this country, clearly there's going to be a considerable increase in the politicization of the role of the judiciary, who must interpret these very general rules and laws. And that again, in British terms, is new and a matter for discussion and debate. There are indeed arguably more fundamental questions about the legitimacy of the entire structure and process. Let me simply make the following point to you. Most courts, whether in this country or in France or Nigeria or wherever, are part of a coherent legal and political system. In this case, the Human Rights Court's judges are elected for 6-year terms from names submitted by members of the Council of Europe. The candidates must be of high moral character, must either possess the qualifications, I'm reading this, for high judicial office, or be juris consults of recognized competence, which means, of course, they need not have judicial experience. Furthermore, the court includes judges from France, Britain, Denmark, and so on, but also, you'll be pleased to know, from Russia, Ukraine, Bulgaria, and even Albania. And I hope it's not unduly odd of me to wonder whether there's something a little odd about human rights in Britain being judged by Albanian judges. Let me also suggest that even if we assume, as I do, that all these people from various places are persons of impeccable character, good judgment, and so on and so forth, surely it is the case that they all come from entirely different legal traditions and structures with different training, different legal experience, and so on. Now, what difficulties is all that going to create? I mean, imagine that a Ukrainian judge was suddenly to be appointed de novo, as it were, onto an American appellate court. I think you might have problems with that. So whether this construct will be sustainable in its present form may itself be a question, but I leave that to you. You're the professional lawyers, I'm not. Finally, let me come, before I sum up, to the European Union. This is, of course, a well-trodden ground, so I'll just offer a few comments. Beginning with the obvious, Britain has, of course, depended for a millennium or two on its relations with the continent. The issue is not whether there should be a relationship, but only how it should be structured. At the same time, Britain has, of course, spent at least 5 centuries since Henry VIII creating a legal and political system that differs quite sharply from what happens on the continent, and none of this is likely to be given up at all easily. Britain's dilemma remains really what it has been since the end of the 1950s. It wishes to be in a major decision-making role in Europe, instead of being faced by a succession of faits accomplis arranged by a European grouping dominated in particular by the French and the Germans. Britain, in other words, fears being left out. On the other hand, Britain does not want closer constitutional and political integration. Now, you can argue, I think, that in some respects matters may be moving Britain's way. Events from German reunification to the recent disgrace of the former German Chancellor, Herr Kohl, have changed and weakened the Franco-German dynamic. Expansion of the EU, as you know, it's about to expand towards 20-odd members or something, will make integration more difficult. On the other hand, the Intergovernmental Conference that's just begun seems certain to produce at least some further dilution of national self-determination, and bitter disputes about a re-weighting of voting powers in the Council of Ministers made necessary, the re-weighting made necessary by the expansion of the EU. For many and perhaps most British people, especially young ones, moving across the channel for holidays or shopping or work seems increasingly natural, and hostility to foreigners seems increasingly quaint. But then older notions of federalism also seem out of date, even irrelevant in an internet world. Reluctance about integration has, I think it's fair to say, grown in recent times because of the Franco-German corruption scandals, because of the EU's, and when I say America's, remarkably foolish reaction to events in Austria, because of the power and pretensions of the unelected officialdom of Brussels, and not least, so far as Britain's concerned, by the massive unpopularity of the single currency project. Actually, it seems a little odd in some ways that the public debate focuses so much on this, because the current level of sterling, the exchange rate of sterling, British interest rates, Britain's position in the economic cycle, in any case preclude any immediate joining of the euro, even if Britain wanted to, which it doesn't. Even business is cool to the idea. Not only that, but according to the National Institute of Economic and Social Research, in the long term, even if, which is wholly unlikely, but even if Britain were to leave the European Union, I repeat, wholly unlikely, nobody has said that they want that. But if Britain did, in the long term, total output would only be some 2% lower, and household consumption some 2.5% less than it would be if Britain is in the EU. So that is not necessarily, or might not be, a dramatic change. The real issues are fairly obviously political and constitutional. The PM, who clearly wants to consolidate Britain's political and especially defence role in Europe, that was part of the reason for his enthusiasm about the Kosovo War, is equally clearly wary of European plans for things like tax harmonisation. You can see why. Governments love to be able to do their own tax arrangements and not have it done for them by an external authority. He's backed away now from the idea of an earlier referendum on membership of the euro, and seems to be trying to change the focus of the whole domestic debate from the issue of the euro to the quite different issue of whether Britain should remain a member of the European Union. Now, in a sense, that's sleight of hand, because nobody suggested that, but the argument that's being put forward is that if Britain doesn't join the euro, then Britain will be driven over the medium or long term into a position where it actually has to leave the European Union altogether. Many of us think that that's an entirely spurious argument, but clearly the government's advisors hope that that will play with the public. Either way, the issue of political integration seems sure to run and run. So what I'm trying to suggest to you by running briefly through these 5 elements is that many of them are interlocked. The Human Rights Convention, for example, certainly has huge impacts on British business. It's going to have huge impacts on what Parliament can and will do, and so on. Let me in conclusion offer a few thoughts about the context for these changes, which, if I'm right, amount to a significant transformation in British affairs. First of all, let me begin with a couple of fairly obvious points. The 20th century has been nothing if not a story in which wars and economic crises have produced unprecedented governmental and administrative growth and centralization. That begins already in 1914, when the whole tenor and scope of British government changed in order to be able to cope with the demands of the First World War, and it's gone on since then through Depression and World War II and so on. But now, we wish to argue for the first time since Cromwell, if not earlier, there is actually no foreseeable real war instead of a pseudo-war like Kosovo. There's no security threat, while the economy on the whole is doing very nicely, thank you. Moreover, the other obvious point is Britain's decline over the last 50 to 100 years. Again, something we all know about, but may need to remind ourselves of. In 1900, Britain governed 20% of the land and peoples of the world. In 2000, 100 years later, it is reduced to 1% of the peoples. In 1945, Britain was one of the 3 leading world powers, victors of World War II. Now it worries about being kept out of Europe. So the changes have been quite dramatic. In these circumstances, what has surfaced, together with, importantly, generational change, is a sharp increase in public impatience with past decline, with failure and constraint, and an embracing of reform and experiment. There is a palpable sense of impatience, I think, with that past, a palpable desire for innovation, for doing one's own thing. As recently as 1939, people by and large trusted their rulers and were willing to do, if not very enthusiastically, what the government asked of them. By 1999, the theme of Kennedy's inaugural in this country had been stood on its head. People no longer asked, what they could do for their country, but rather what the government could do for them. Government had become something of a service industry. Together with that has come a revival, very interesting I think, of that general bolshiness and unruliness, which would have been entirely familiar to any pre-Victorian British politician. I mean, if you think of either the elder or the younger Pitt, or Castlereagh, or Melbourne, or Palmerston, they would have understood entirely what's going on. It's been one facet of the notably strong civil society, which is the compound, and it's always been compound, British nation, the nation state. It's hardly surprising that in such a climate, each of Mr. Blair's reforms has fueled a demand for more, for regional parliaments in England, greater powers for Wales, an elected upper house, separate powers for London, and so on and so forth. From the longer perspective, therefore, it may be that the recent over-centralisation in Britain, it was that which was the aberration, not so much the current devolution. Even until the 1960s, wide local autonomy was the norm. Scots and Londoners and Lancastrians and people in Kent could levy some of their own taxes, run the local police, own their own water, build their own schools. It was only after that that this was all taken over by central government. In such a climate also, while close association with Europe is desirable, centralism seems diametrically at odds with the entire revival of social and political localism, the introduction of a Bill of Rights and parliamentary reform, which look like an entirely proper rolling back of excessive statism. So that from this point of view, the cracking of the carapace of controls once created to administer wars and empires, under those cracks, what's emerging includes, but is not confined to, some highly traditional social and political phenomena, as well as huge innovations like the Human Rights Convention and the end of the hereditary peerage. Even people sympathetic to Mr. Blair seem concerned that there's no overall design to these changes, and there clearly is not. But in such a country and such a time, it is not clear, at least to me, that some preconceived pattern would have been possible. Mr. Blair could never have been in more than partial control of such a process of change. And it would, at least in my opinion, say something quite alarming about Britain if he could have been. Thank you very much.
We have some time for questions and comments. Harry, will you hand it yourself?
Delighted, thank you. At the back there, sir.
Could I ask a comment on the reaction to a potential loss of sovereignty that's going on with the European Court of Human Rights, European Human Rights Law? Have there been any reactions by the general public to that kind of loss of sovereignty that's going on with being able to take cases out to the European Court of Human Rights, just generally being governed by foreign law?
Well, there are quite different strands in play here. On the one hand, for many citizens, the idea that you can sue the government, that you can circumvent this enormous executive power, is a thoroughly good idea. Okay? So in that sense, some of the human rights stuff is being welcomed. On the other hand, to a quite surprising degree, in business and even legal circles, the impact is not fully appreciated. That may strike you as odd. Let me tell you why I think that. I have a son who's a member, I believe in good standing, of a senior London city law firm. And he was interested a while ago, and in fact he is in human rights law and has made a bit of a specialty of it. And in fact one or two of the senior partners in his firm have sort of muttered to him that maybe he's wasting his time on this stuff. And Christopher, that being my son, reckons that the legal profession and indeed most of business has really barely begun to understand what is about to hit it. When it does get hit, of course, it will be too late to do anything about it in the short term. So on the one hand, there are elements in this which are hugely popular. On the other hand, the impact is not really fully appreciated. Okay? So,
While we're on the issue of the Human Rights Act, one thing that you didn't mention in an otherwise exhaustive description of what's happening is that once a court makes a declaration of incompatibility in respect of a statute, it then bounces back to the minister responsible for that area of the legal system. As I understand it, the minister then has the ability to modify the legislation without having to go to Parliament. And this strikes me as one of these peculiar examples of the current government wanting, or at least seeming to want, to give power to the people, either through devolution or through the Human Rights Act, but at the same time trying to claw some of it back, either by fixing elections or introducing legal subtleties into the changes, which in effect retain a great deal of control. I wonder if you could comment on that particular aspect, if you
you're
if you
certainly
could.
right to argue that the government is trying awfully hard to create in the small print circumstances in which real power stays with government. On the specific point that you raised, it seems to me that there is something yet to play for in the following respect. If there is a declaration of incompatibility, it may be a matter for debate as to whether new legislation is required. If it is, of course, the legislation will then have to be brought before Parliament with everything that flows from it. You are right to say, of course, that the minister may, in some circumstances, depending on the character and scope of the incompatibility that is declared to exist, be able to pass a regulation. But that, of course, in current circumstances, can at least be held up for there is inspection by the House of Lords, for example, because regulation itself will now be subject to more questions than has been the case. Now, exactly how this will play out is simply not yet clear, because everybody is still trying to fit the pieces together. But my understanding, for what that's worth, is that it is not just a matter of ministerial power being exercised so as to remedy these incompatibilities.
Right, although it is certainly a long ways from being able to strike down a statute as
Indeed.
void.
Oh, indeed. So I think
I have two questions, both concerning the economic role of the United Kingdom and the European community. The first one is, if I got you right, you mentioned that the business relations with continental Europe are of minor importance for the United Kingdom, and actually I doubt that. I think that the exports from the United Kingdom to the continent are of vital importance for almost any business in the UK, in particular for the finance industry, and that leads me to the second, for the financial service industry, and that leads me to the second point, the role of the UK in the process of European monetary integration. Do you really think that on the long run the UK can opt out of the European monetary integration? I think, as I see from the German point of view, that in the UK there are tremendous tensions between the city, that is very much in favor for the common currency, and the public in the UK, which has a strong majority against the introduction of the euro in the UK. But I think on the long run, the role of the city will be dominant, and the city will prevail, because London is about to lose market share of financial business to Frankfurt and other continental European capital markets.
The argument you make is in fact the argument of the pro-EMU people in London. Let me tell you why I don't agree with you. In the first place, the city is not united on this. A number of the bigger businesses and the bigger banks are indeed, as you say, in favor of joining the euro. Medium and small business is not. It is not. So business itself is very far from united. The Institute of Directors, for example, is against, and other people for. So you need to be more differentiated, I think, than to say business is for the euro. Secondly, the evidence so far is that London has been gaining business and not losing it to Europe. Sorry, financial business. Now, the argument that is therefore being made is that what's been happening has been happening because the expectation is that Britain will join. And that if ever it became clear that Britain made an irrevocable decision not to join, ever, then business would indeed leave London and go somewhere else, presumably Frankfurt. But this is an expectation about the future which is inherently not demonstrable now. Various factions take various views on this. As to the question whether it is, well, sorry, let me go back. On the question of exports, it's not actually entirely clear that the argument that you quote is right. There are two reasons, for example, for saying that Britain's exports to Europe are important is true. But that Britain's exports to Europe are a majority of British exports is not true, except in some industries. Britain exports more to elsewhere. Interestingly, British financial links to the United States in particular and to the outside world are arguably strong. Britain, for example, is the largest foreign investor in the United States, bar none. I think when I last looked, the Dutch are in the second place, and the Japanese are in third. So Britain's links are much more diversified, economic links, much more diversified than some of the debate in London would suggest. Whether it is inevitable in the long run is itself a matter for debate. As you know, John Maynard Keynes once argued that in the long run we're all dead, and then we won't bother about it. Okay, so we're not bothered about the longest term. I draw to your attention an article with which don't mean to associate myself, but it's interesting that it's the first time I've heard the argument made. In the current issue of Foreign Affairs is an article by Kotlikoff, who's an economist at Boston University, and Neil Ferguson of Oxford, which argues that the European Monetary Union is very likely not to survive. And the argument that they put, which I simply alert you to, I don't mean to defend it, is that the generational problem will ruin it. That the discrepancy between the amount of resources required for social security for an increasingly aging population and the problem of taxing a proportionately decreasing labour force will wreck the EMU. Now, I don't argue that the EMU will be wrecked, but it is a view that is interesting. Yes. And then he first. One follow-up, and then you.
Okay. Let me frankly say this. I write a PhD thesis at the University of Heidelberg concerning the European Monetary Union. There's almost a whole industry of critics of the European Monetary Union, whose business is to produce new skeptic theories concerning almost every aspect of the monetary union. I totally disagree with that. And I think that came pretty much out of what you said. If London, on the long run, would not give a clear perspective to the financial industry to join the European Monetary Union within 4, 8, 6, 10 years, whatever, I think a lot of business would shift directly from London to wherever, not necessarily to Frankfurt, but would definitely leave the city. I think foreign investors play a very big role in the cities. London accounts for 50% of the world currency trading, and I doubt that it can hold that 50% stake if it joins, or if it decides not to join the European Monetary Union. And you see it right now with a terrible high pound sterling. It's a very big problem for British exports, right?
Of course. On the other hand, the British economy is, for the time being, look, my crystal ball is absolutely no better than yours, and probably not as good if you're writing on this very topic. So I feel uneasy about trying to predict. But there are all sorts of arguments in play in the public arena that may have a bearing on this. Let me give you a different argument on this. There is now some debate about, including debate in this country, the high point may not have been reached, perhaps even past, for the ascendancy of banks in general and central banks in particular, because of the importance of e-money. That the whole, that what is money and what gets paid for how and how funds are transferred is, so people who know about this tell me, itself changing, not so much its meaning, but the phenomenon is changing under our eye. Now what that will do to establish forms of flows and centers in which flows are directed, I have no idea. I wouldn't myself have thought that EMU is likely to break down, but that EMU is likely to encounter problems as and when there is a recession in one of the major EMU countries. That seems certain. How it will be coped with is quite unclear. So, what was it that you quoted to me earlier today? Was it Yogi Berra that it's a bad business to predict, especially about the future? Sir?
Yes, let me bring you to the political aspect of the European Union integration process. I believe there is a thesis that claims integration at the European level would reduce centrifugal forces in member countries. How do you assess the validity of that claim in terms of the not so viable prospects for integration you described, and in terms of the British interest on that issue?
I don't think I quite follow you.
I was trying to say that there is a claim that integration at the European level could somehow reduce regional movements in member countries that seek independence. And as I understand from your description, the prospects are not so positive in terms of full integration or having a monetary union and so on. So how do you see that argument? How do you assess that argument? And how do you see that in terms of Britain's interest in coping with regional issues?
It seems to me that and almost everything one says about this is in an area which is very controversial, as I'm sure you understand. So I'm giving you a view which is, I make no pretense that these are the laws of Moses I'm giving you, okay? Views about the European Union and the desirability of integration really vary quite widely, even on the continent. For example, the willingness of the Christian Democrat Party under Helmut Kohl to move towards integration was not the same as that of the willingness of, say, the Bundesrat, who has been much more hesitant about various forms of integration than the dominant Kohl administration was. Even so, that's true even in Germany. Similarly, in France, there are regional differences about who wants to go in what direction and so on. As I say, my own view is that expansion of the EU will make the old dream of a tight political integration into the United States of Europe less feasible than it has been. Now, I might be wrong about that, but that's the view I'm putting to. That does not mean that the degree of what confederation has occurred will disintegrate. It just means that the kind of single state or quasi-single state that at least some of the promoters of the European idea from the 1950s onwards wanted to move towards, that seems now much less likely to happen. If you mean by regionalism, what happens to people like the Basques and the Scots, if that's what you had in mind? I report to you that simply as a fact, that for the time being, the desire in Scotland to be an independent member of the European Union, as distinct from part of a more federalized Britain, the desire to be an independent member seems to have diminished. On the other hand, what seems to be emerging at an economic rather than political level is a degree of regionalism cutting across borders. For example, the Burgundian thing cutting across the French and German borders, and there are similar phenomena in other areas. So political integration, I would think, is not, if by integration you mean a single state, is not really for the time being in sight. Whether it's going to be in 50 years, I've obviously no idea. If you mean by regionalism economic arrangements that cut across borders in ways that happen to be congenial to a particular group of cities and counties, yes, that's happening, and I would expect that to strengthen. Am I answering your question?
Yes, but how do you feel? How do you feel it would be, say, if this whole project fails? Now that these economic entities are somehow expanding across borders, and there is some kind of new identities developing, while at the same time the traditional nation states could have a diminished role in all that.
You're asking what seems to me to be the $64,000 question, which I would formulate like this. If the graduate students here, that generation, okay? If that generation of young Germans, Frenchmen, Italians, etc., one day, if these people one day see themselves as being members of a single Europe, in the way that their parents and grandparents have seen themselves as being members of a French state, a German state, Italian state, and so on, then the world would have changed. The world always does change. Maybe it'll go that way. I don't myself see the signs of that for the time being, except for a numerically fairly small elite. The view towards that kind of Unitarian view is, I think, much more highly developed among the tertiary educated, the intellectuals, the people who naturally talk to chaps across borders and for whom borders are a damn nuisance, that sort of thing. My strong impression is that for the time being, at least, that is a minority of the electorate in almost all the countries we're talking about. Whether it will become a majority, I don't know. I repeat, if it does, okay, the world will have changed and a European state will have been created. But that's, okay, so what else is new? States disappear and get created all the time. So I think you wanted to have a go.
I wanted to ask a little bit more about the first past the post and relate it to your statement, which doesn't surprise me. Tony Blair has no one sort of objective or theme in mind, and contrasted with New Zealand, where I think they very much had a policy of Rogernomics on for about 15 years of decent relations in a vast variety of ways. It really was remarkable. One of the last reforms they made was to change their first pass of the post, which had the effect of future legislation perhaps was going to be much more difficult, including repealing all the hard-won gains. And I guess to relate to a comment, my sense is that if you have an agenda, a very good last element once you think that the energy is almost dissipated is to make this change. But if you don't, first past the post makes a lot less sense.
I find the following difficulty in commenting on the principle you're talking about. There's also a matter of scale here. New Zealand has about 3.5 million people and Britain has about 60, or just short of 60. Now that creates different dynamics right there, simply because of a function of size. But it is true, of course, that, if I understand you rightly, and I quite agree, that proportional representation makes changing governments more difficult. It means that in many respects you can't simply win electorally or otherwise and then get something through that you really want to get through. That it's a much more laborious, ongoing process of debate in which you, dare I put it this way, wear down the opposition if you can. I'm not sure what to make of this. That seems to me to be one argument actually against PR, but that's just my personal view. I mean, do you favor PR? Do you find it a helpful way of doing things?
No, but I guess my point being, I can fully believe Tony Blair doesn't really want it, because if you haven't got an agenda that you've 9/10 finished, and as a legacy for the future, a great last thing is to make it hard to undo. by switching this. And I think that was the view in New Zealand by many.
Okay.
I think maybe that ought to be the last word, but I can't resist saying that I was in New Zealand at the time that MNP was being proposed, and it wasn't the politicians' plan. It was an accident. That is to say, they said that they turned it over to a commission, which proved to be much more dutiful and single-minded than they had anticipated. I know that the judge who chaired the commission is one of these people who goes straight ahead into a wall. And the commission then proposed this thing, and the politicians said, "Okay, well, you can have a referendum on it if you like," thinking, of course, that it would be defeated as being incompatible with the fundamental genius of New Zealand's British-derived institutions. And then the people, being thoroughly fed up with the politicians, said, "We'll vote for anything they don't want." So it was a complete accident, and the politicians were terrifically disappointed on all sides that this thing had been approved. Anyway, Harry, let me thank you very much for a lecture that was both comprehensive and incisive. It was very difficult to do both of those things, but I think it's fair to say that you succeeded admirably in doing that. We're all very grateful to you.